Hey there, this is Andy again. In our last few videos, we've been discussing why a written contract is important for your home renovation or new home construction. And we've covered some of the issues that make construction contracts unique, such as various types of pricing, defining the scope of the work, and getting lien releases when you make payments. Today, I want to review a few of the legal terms and provisions that can be inserted into contracts that can put you on fair footing with your contractor and can help expedite things if problems arise. First is something called a dispute resolution clause. Look, everyone enters into contracts with the best of intentions, but you want to provide for what happens in the event a dispute arises on the job. You want to have a way that these disputes can be handled and resolved quickly without it costing you or the contractor a lot of time or a lot of money. It's therefore important that you have a provision that outlines a streamlined dispute resolution process for on-the-job problems, such as identifying an initial decision maker, maybe the job's architect, who can decide who is right and who is wrong in the dispute, and who can even mediate a dispute right on site. This person will need to get paid for that work, of course, but having such a provision can save you literally hundreds or thousands of dollars in time and attorney's fees. Next thing you want to make sure is you address termination of the contract. Sometimes conditions on the job get so bad that one party, either the owner or the contractor, decides they want to terminate the contract. It's important to define the circumstances that would allow each party to terminate the contract, either with cause or without cause, and what that would mean in the way of costs that are incurred or damages that have been suffered. The more clearly such a provision is written, the easier it will be to move along to another contractor should you decide that that is what's in your best interest. Finally, you need to address attorney's fees. Look, if you end up in litigation with a contractor for any reason, you're going to want to make sure that you have the right to make a claim for a recovery of your attorney's fees. However, in Florida, there's no automatic right to claim your attorney's fees from the other party to a lawsuit. That's why it's necessary to add a provision to your contract that provides that if litigation occurs, the prevailing party in that lawsuit is entitled to recover its attorney's fees from the losing party. Without such a provision, every dollar you pay to your lawyer is a dollar you will never see back, and that's going to lead to you to make some very tough and expensive decisions down the line. Look, projects don't always go as planned, especially in Florida, and this is why it's so important to protect yourself with a fair and reasonable contract before the work begins. Your contractor shouldn't object to a reasonable contract with these provisions. If they refuse, that's going to be a red flag for you. And this is why clients hire us to represent, advise, and guide them throughout their entire home build or major renovation project as part of our Renovation Concierge Retainer Plan. Call our office at 561-361-8700 and find out how we can help you have a successful renovation project.